Well, you finally land that sponsor. The email arrives and the deal looks great to you. The money looks good. The contract is only a few pages long, so you skim it, you sign it, and you start recording the ads. You publish your episodes, and then nothing. 30 days passes, no payment. You send an email, another 30 days. Network says they're waiting to be paid by the agency. The agency says they're waiting to be paid by the advertiser. 90 days out, you're still waiting, maybe even 120 days. And that's when you go looking and discover a clause in the agreement that says you'll only be paid after the agency gets paid. So you did your job. The ads ran, sponsor got their ad messaging, and you are still waiting for your money. And believe it or not, that's only one of the ways that folks get caught up and into trouble in these deals. So today, we're talking about what you must know before you sign that sponsorship agreement. Welcome back to Legit Podcast Pro. I'm Gordon Firemark, entertainment, media, business, and intellectual property attorney. In some circles, I am known as the podcast lawyers. And for more than 3 decades, I've helped creators, entrepreneurs, producers, podcasters, filmmakers, media businesses, and the like navigate the legal and business side of what they do. Now, today we are talking about sponsorship agreements. Whether your show is the business itself or if you're using it as a tool to grow your own business, another business, sponsorship opportunities can be an exciting thing. They can generate revenue. They can build credibility. They build and create valuable relationships, and they'll help you support the growth of your platform. But sponsorship agreements can also create problems when the creators sign first and ask questions later. The reason for that is because contracts are not really about what happens when everything goes right. They're more about what happens when things don't. So the opportunity looks like this. Now, most creators spend far more time trying to get sponsors than they spend actually looking at and reviewing those sponsorship agreements. And that's understandable. Landing a sponsor feels like validation. Someone believes your audience has value. Someone wants access to the kind of trust you've built. Someone is willing to invest money and get in front of your listeners. Very, very exciting. But excitement can cause us to overlook details. I've seen creators negotiate endlessly over price. They'll spend almost no time watching for the nitty-gritty of the agreement terms themselves. And that's backwards, because the contract determines whether you'll actually receive the benefits that you think you're getting. Now, before we go further, let's clear up a common misunderstanding. Not every sponsorship agreement is the same. Not every agency is trouble. Not every sponsor is a bad guy. However, sponsorship deal usually involves payment in exchange for some kind of promotional exposure to your audience. A brand partnership is often a more broad collaboration of some sort. An affiliate arrangement pays commissions based on referrals or sales. And an endorsement deal might involve permission to use your name, image, voice, reputation, or likeness to promote products and services. These are all sort of under the lump category of sponsored deals, but the distinctions really matter because the rights and obligations can be very, very different. Now, when creators don't understand these differences, that's when problems really start to show up. So let's look at a couple of examples here. The traps. First off, the payment trap. A creator lands a sponsorship worth several $1,000s. The ads get recorded, the episodes get published, everything is successful. And as I said before, that payment never arrives. Repeated follow-ups, and the creator sees that clause that makes everything contingent on the agency receiving payment from the advertiser. Now, the creator did all the work and delivered everything that was promised and is now financing somebody else's advertising spend and a collections problem. And this happens a lot, far more than people realize. One of the first things you need to look for in your contract is, when is payment due? Is it due upon signing or on delivery, or is it net 15 or net 30 of delivery, something like that, and maybe net 60? If it says it, then you have a right to hold the party accountable for that. Or is it only after someone else gets paid? Well, as a creator, your position should generally be simple. You performed the work you were expected to, you need to be paid. And we'll talk about that a little further, but let's move from money to something many creators overlook entirely: the ad read that itself became an ad used on other platforms. Podcaster records a host-read ad. Sponsor loves it. Everybody's happy. Months later, this creator is, out there scrolling social media, surfing YouTube, who knows what, and suddenly sees their own face, their own voice, that their own endorsement, and that ad is now being used in a separate paid ad on Facebook or Instagram or who knows where, YouTube. The creator thought they were recording a sponsorship message inside their podcast. The sponsor believed that they had acquired a broader set of usage rights. The agreement allowed the reuse. Now the creator has effectively become the spokesperson for the brand. Probably not what they intended. Now, maybe it's fine, but maybe not. The point is, you need to know these things before you sign, so you have the ability to negotiate, discuss, and perhaps ask for a better price. Now, can the sponsor reuse your ad read? That is an important question to look at in the contract. Can they use your name in other platforms, other media? Can they use your likeness? Can they run paid ads using your content, your endorsement? And if so, for how long? In what media? Are there any approval rights? Those answers need to be in the contract. But that's not the only surprise that creators encounter. The other one has to do with exclusivity. A creator signs a sponsorship deal with a coffee company, for example. A month later, another opportunity comes up. It's better, it's more money, better fit. And the creator is all excited about it. And then they discover that the contract with the original coffee company prohibits promoting any other competing beverage company. Notice I said beverage, not just coffee. Any beverage company. So now, suddenly, a lucrative opportunity just vanishes, disappears. Exclusivity provisions are common, and you can understand why your sponsors don't want their competitors also being mentioned on your show. And they're not necessarily bad. They want that protection against paying you while you're simultaneously promoting their competitors. Totally understandable. But exclusivity needs to be reasonable. The category needs to be narrowly defined, and the duration of that exclusivity should be very limited, usually maybe only 30 days after the campaign ends. And you should understand exactly what opportunities you might be giving up, because exclusivity has a cost. Sometimes it's very expensive, and you're going to want to negotiate that and make it the sponsor's problem, not yours. So now let's look at a situation where it's not about the creator at all. This time, it's the toxic sponsor. Creator signs a deal with the sponsor, the campaign launches, everything's going great, and then the sponsor gets involved in some kind of a public controversy, negative headlines or consumer backlash or bad press. Creator no longer wants to be associated with that company, and the audience starts asking hard questions. Creator wants out, but the contract doesn't provide a way out. The creator is contractually obligated to continue promoting a brand that they no longer support. This is why it's important that there be a termination clause in the agreement. It's why brand safety provisions are important. This is why reputation protection matters. The contracts need to protect both parties, not just one. So you need to negotiate. And hey, speaking of protection, let's talk about a risk that a lot of creators don't even realize that they share with their sponsors, the FTC problem. A creator promotes a product they genuinely like, and the sponsor pays for that placement. Creator mentions the product, but then the creator doesn't adequately disclose the sponsorship relationship. No clear verbal or visual disclosure, no written disclosure, no indication that compensation was involved. Well, that becomes a problem. The Federal Trade Commission, the FTC, is the organization, the agency of the U.S. government responsible for truth in advertising, and they expect disclosures when there's a material connection between an endorser or the brand. The size of your audience doesn't matter. Size of the deal doesn't matter. What matters is whether listeners understand that a business relationship exists. If you got paid or you received free goods or anything else of value, they need to know that because it affects their thinking about how to make purchasing decisions around that brand. A sponsorship isn't merely an advertising opportunity. It is a legal relationship. And that brings us to one final story, the deliverables disaster. Here we have a sponsor who believes they purchased 3 host-read ads, a newsletter mention, 2 social media posts, and a promotional video clip. The creator believes they only agreed to record 3 ads. Now, nobody's acting in bad faith. Nobody's trying to cheat anyone. The trouble is that the agreement wasn't specific enough. The deliverables weren't clearly defined. That's important. That ambiguity creates the conflict. One of the simplest ways to avoid disputes is to make expectations as explicit as possible. What exactly will be delivered? How many placements? On which platforms? By what dates? That kind of specificity prevents these misunderstandings. At this point, sponsorship agreements may sound like a minefield, and they're really not. They're great. They're fantastic tools for monetizing your show when they're structured properly. And that brings us to our final act in this discussion, the professional creators checklist. So before you sign any sponsorship agreement, make sure that you understand at least these issues. Payment: how much, when, under what conditions? Deliverables: exactly what are you promising? What are they promising? What are the usage rights? Can the sponsor reuse your content, endorsements, likeness, or ad reads? And exclusivity: what other opportunities might you be giving up? FTC compliance: who is responsible for disclosures and approvals? And then termination: how can either side end the relationship if that becomes necessary? What happens brand safety-wise if one side becomes a reputational risk? What about approvals? Do you have approval rights over how your content, voice, image, and endorsements are used? And ownership. This is important. Sponsors generally purchase advertising, but they don't purchase your audience, and they don't purchase your podcast or the content. They do not purchase your intellectual property, and it's important that we always stand firm on that. They do not purchase your brand unless the agreement specifically says otherwise. So the goal is not to become difficult, it's to become professional. Don't be a statistic, be a collaborator. Professional creators understand the value of the trust that they've built. Professional creators understand the value of their audience. Professional creators understand the value of their reputation. And professional creators don't give away rights without understanding exactly what they're giving away and making sure they're receiving reasonable value if they do. This is one of the topics I cover in much more detail inside my Easy Legal for Podcasters program, where we dive into sponsorship agreements, advertising arrangements, intellectual property rights, team agreements, monetization deals, and many of the legal issues that creators encounter as they grow. You can also get access to a free sample lesson by going to gordonfiremark.com/level-up. Now, sponsorship agreements are not just paperwork. They're important. They are business deals, and every business deal has consequences and deserves real attention. The right agreement can protect and create clarity, solidify relationships, and help both sides succeed. The wrong agreement can create confusion, disputes, delayed payments, and missed opportunities. And no agreement is an absolute recipe for disaster. So, before you sign your next sponsorship agreement, slow down. Read carefully. Ask questions. Be sure you understand what you're agreeing to, because the best time to solve a contract problem is before it's ever signed. You can reach out to me for help. Just visit gordonfiremark.com, or actually firemark.com for the law side of my business. And if you'd like access to lawyer-drafted sponsorship agreements, ad agreements, endorsement contracts, co-host agreements, guest releases, and dozens more other kinds of forms designed specifically for podcasters and creator businesses, head on over to podcastlawforms.com, where you'll find templates, guidance, and resources designed to help you build your podcast and your business with confidence. That's it for today. Thanks for joining me on this episode of Legit Podcast Pro. I'll see you again next time. Thanks.